Good evening, you're watching Left, Right and Centre. I'm Nidhi Razdan. Tonight, the Centre submits over 600 names to the Supreme Court in the black money probe. But will it really lead anywhere? As political parties continue to trade charges, the question is, will the big fish ever be caught? Well, that's our special focus tonight. After being ordered to do so, the Centre today gave 627 names of people with foreign bank accounts to the Supreme Court, all in a sealed cover. The court did not reveal the names and has asked the special investigation team that it set up to go through them. Interestingly, the SIT chief, Justice M.B. Shah, has said that the list is the same one that was given to his panel by the government in June. The court now wants a status report on the probe by the end of November and has set a March deadline for the initial probe to be completed. While placing the documents before the bench, the Attorney General Mukul Rohatgi said that the details of the account holders are from the year 2006, which was supplied by the French government to the centre in 2011. He said that the data was stolen from HSBC Bank in Geneva that later reached France, from where the government got the information. He also informed the court that some people have accepted that they have accounts in foreign banks and have also paid tax for the same. But joining us now to explain why all of this could actually turn out to be far more complicated and difficult than what it appears to be right now is my colleague Sudhir Ranjan Sen. Sudhir, you've been speaking to your sources here in the government today, in the Enforcement Directorate and so on. What are you hearing? One gets a sense that it's not going to be so easy to trace this money and the real account holders.
Well, to begin with, Nidhi, what the understanding that we are getting is that, off that list, it seems that about 150 odd people to 120 odd people have voluntarily come ahead and said, yes, we have accounts and here is the tax. Some have even paid the penalty and there is no there is no liability against them as of now. Mind you, income tax evasion is a civil offence, it's not a criminal offence. Only in certain cases, as in the case of Mr. Burman, has the income tax launched criminal proceedings saying that he willfully and he deliberately hid the fact that he had an account and that there was money in it. So in these cases of criminal charges being put against people are very, very few. In fact, what we understand is it's under 10, and those are the names that the government has revealed to the court, because the protocols that you have signed, the agreements that you have signed very clearly say that nobody else but the income tax department can handle these accounts. Now, what is happening at the income tax, where the investigations are happening, where the SIT is also going to lean on after this to get to the bottom of it. The income tax department can at the most, or is at the most, being able to send out notices and summons. Mind you, it is very difficult on the basis of stolen documents to carry out raids and searches unless and until the information in the list is also corroborated by something on the ground, which then justifies for more action. In the process, very many people have said that, we don't have any accounts. And the income tax department or government of India cannot go back to the banks and say, please verify because it's a stolen document.
I think that's really useful what you've told us, because that explains how complicated and complex this all of this is, and it's very easy to say we'll bring black money back, but it's much more difficult when you look at how it already plays out. Sudhir Ranjan Sen, thanks very much for joining us tonight. Well, the question then is whether we're ever going to know who really has all those hundreds of crores stashed away abroad. The question also is whether our focus is all wrong. Most of the black money that is generated in this country is within India itself. It is not outside India. So are we just looking in the wrong place? Joining us on the program tonight, we have Pinky Anand, the Additional Solicitor General of India, who's also a senior leader of the BJP. Ved Jain, Chairman of the National Council on Direct Taxes with ASSOCHAM. Aarti Jairath is here in the studio with us. Dr. Ajay Kumar of the Congress. And Mahesh Jethmalani joins us tonight from Mumbai. Mr. Jethmalani, let me ask you first. We have this situation today where you now have the SIT chief, Justice Shah, saying on record that the 600 plus names given to the Supreme Court today by the government are the same names that the government gave to us in June, and we're back to square one. I just want to know from you, how have we moved forward today on this story, frankly?
Well, you've certainly not moved forward, but if there was any attempt to stall it by this government, if any attempt, and I'm not saying it's a willful attempt, if there was any attempt, misconceived or otherwise, to set back the investigation, that has been put an abrupt halt to by the Supreme Court. And I don't know, look, Nidhi, there's a German account and there's a French account. The German account has 800, the French account, which comes from the HSBC Bank, Geneva, has 627. Now, I don't know what they gave in the past. All this requires clarity. We need a clear enunciation of which, the government should come out with some documents which evidence what they gave to the SIT in June 2014. Were it both the accounts, the French and the German? Was it only the German? In which case, why do they give only the French today? If they were going to duplicate accounts given in June, why do they only give the French ones and not the German ones today?
No, but
so I'm not quite sure what this is all about, but be that as it may, the matter ends now. We should all be very, very sanguine about the prospects of getting back the money and not negative and pessimistic. There has been a serious obstacle for this investigation. These names have come out since 2009, and those responsible from 2009 for delaying this process are to blame for any delays in the names coming out and the money is being recovered. In fact, a lot of the money may have been siphoned out further and put into other jurisdictions.
One of the main questions, though, that many people asked today was that, look, this was an SIT that the Supreme Court set up, okay? If the SIT already had these 600 plus names, what was the need for the court to then ask the government to submit them separately today? Now, are you saying that that exercise was not futile because at the end of the day, the court has sent out a message to the government that we are watching and we are closely monitoring this probe, and that in itself is important? Is that what you're saying?
Yes, and not just that. The SIT has got these names only in June, and I'm told that some process is already underway. And now, in case there's any public misapprehension, like you seem to be suggesting there is delay by the SIT, which I don't think it can be because it's monitored by the Supreme Court. I mean, it's utterly absurd to suggest that a government from 2009 has sat on this and done nothing, and an SIT given the names in June 2014 is being absurdly slow. And that SIT now has been told in any case to complete this first status report by November and finish the entire investigation by the 31st of March. So if anybody has any doubt about the SIT, there's a timeline now set by the Supreme Court.
Okay, so let me ask Mr. Jain then. Mr. Jain, would you say, I know you've had concerns that if all names are made public, let's face it, and I want to clarify here that everybody who has bank accounts abroad doesn't necessarily have illegal money stashed in them. Okay, that's the bottom line. And one of the arguments that both the governments took before the court was that naming people would then be an amount of violation of privacy and it would be unfair. If you're able to prosecute someone, sure, go ahead and name them. So A, are you satisfied today that the court did not reveal the names? The names are with the SIT. Nobody really knows what's on that list. But B, do you believe we are actually a step closer to getting the bad guys?
See, what the debate has been going on. In 2009, this issue came up, and in 2011, the Supreme Court ordered that this investigation should carry out, and they wanted to carry out the investigation. And the court was concerned that despite spending 3 years, this investigation have not moved forward. And the government stand of the earlier government and the present government has been that we cannot share this information in public domain because it violates the treaty under which this information has been shared by the French government. Now that's the issue which was there with the issue. Now the Supreme Court insisted, yes, you provide the information. But I believe the Supreme Court at the same time also realized, yes, the government may be right when it says, yes, this information cannot be put in public domain. And that's why when this information was submitted today before the Supreme Court, they did not open the sealed envelope. Because there were 3 envelopes. One was the exchange,
that's right, the name, the status report,
which contain name. Second was the correspondence between the government of India and the French government. That's an important thing. And third, what is the status report what the government has done. And that's why they said, let us give it to the SIT, let the chairman and vice chairman open this up and take up the issue. And then government also, if you know that the government also made a presentation today before the court that we are still bound by the treaty and confidentiality. And then the court made a remarks, look, chairman and vice chairman both are the retired Supreme Court judges and they understand and they know the law. And that's why they believe they will carry out the investigation. And the government has a right to make a representation there also that this information should not be made public information. Now, what will happen with this is, now the all investigation will get expedited. Now, the Income Tax Department, which has been carrying on the investigation for the last 2-3 years, will also be under pressure to
I think that's the point that Mahesh Jethmalani was making as well. The point is that there is now a time frame, that there is at least a sense that we're heading somewhere with this. So let me just ask Dr. Ajay Kumar of the Congress party that obviously, Dr. Kumar, we've seen the Congress and the opposition really go after the government on this issue for the last couple of days, perhaps rightly so because of all the political rhetoric that we saw on the black money issue in the election. But as Mr. Jethmalani also pointed out, the fact is that This SIT was announced by the Supreme Court in 2011. The UPA government didn't act on it. In fact, it opposed it. The Modi government is at least seen to be acting, to be moving on the issue. Now, it may make, fumbles on the way, but on day one, they constituted it. Now you have a deadline. They've been forced into a deadline. There seems to be forward movement on this issue now, even though the onus was on your government to move forward back then. Ajay Kumar.
Nidhi, one is that there's a lot of miscommunication in the media. First of all, just a couple of facts. One was that the UPA government modified over 81 tax treaties so that we could get the information. They signed 14 new tax treaties. The Directorate of Foreign Tax reviewed over 33,000 crores of tax of related transactions. The transfer pricing, which was where there was a lot of opportunity for tax evasion, goes up to the figure of 30,000 crores. The Government of India set up a high-level committee which had the Enforcement Directorate, the CBDT, the CBEC, and the CBI.
But you didn't constitute the SIT that the Supreme Court asked you to. You didn't constitute that SIT. The fact is, this government did that, right?
No, and I want to again, highlight a very important point, Nidhi. The government went with the contention that we have created a high-level committee of the total investigative power of the Government of India, which is Enforcement Directorate, CBDT, CBC, CBI. And there was at that time, so the miscommunication is the Supreme Court did not make a comment on the SIT formation. We said that the whole government investigative setup cannot be bigger than this. So now there is a miscommunication, etc., saying that the SIT was not set up. You tell me today the SIT says we need an Enforcement Directorate. So a high-level investigative committee which has CBDT, CBEC, CBI and Enforcement Directorate, there's nobody bigger than this who can get you the information.
What you make is an important point. I just want to take that to Pinky Anand, that in fact what we also learned today, Pinky Anand, is that while today's government did set up this SIT, the same SIT hasn't, it has asked for the ED to be attached to it for investigations, which they said, hasn't happened until now. So there is a sense that while this government was trying to show that it's moving forward on this issue, there is also a lack of political will here to really seriously move forward with it, which is why you've seen the kind of absurd somersaults taking place in court over the last few days.
No, I don't understand what is the rare somersault that you're talking about. We are talking about an action which has been started and initiated and pushed by the government to bring back black money. Now, for that purpose, A, investigation was going on. B, you have had the SIT itself which was formed. C, you've had the investigation being shared with the SIT. D, you've had the names being given to the SIT. What has happened in the last couple of days is the Supreme Court has asked for the names, which names have been also given over, so that there is no issue whatsoever on any kind of keeping back from either the public domain or otherwise. We are bound by the treaty, an international treaty binds us. The government cannot go against the treaty. So ultimately, however, when the Supreme Court directs, we have given it, the same has been kept in sealed cover, which reinforces the whole issue of confidentiality and not leaking it out to the people at large. You are having the SIT now functioning within a certain domain, and I think that's what the whole action is about.
Yes, but the point is that your hand was forced on it. At the end of the day, there was a selective leak of some names that were given to the court, of which, frankly, they were those names were a damp squib. You had somebody who had already paid a penalty for his tax violations. So at the end of the day, what the Supreme Court said yesterday, for instance, in court to the government wasn't exactly a compliment. It accused the government of trying to shield those with illegal accounts, put in a protective umbrella around them. So, in a sense, you got arm twisted into this.
Let's get our facts a little straight. The very clear understanding is that the treaty binds you not to disclose the names of people unless and until prosecution has been launched against them and there is a prima facie case which is made out. You can't be indicating names of people in the public domain when tomorrow they may even be found not to be guilty of any offense or guilty of any criminal activity or any black money, supposing the accounts are legitimate. So therefore, the entire process cannot be a knee-jerk one to say there are names of the government should release all of them. Even today the names have not been released. They've been given in a sealed cover, and the court has made it very clear in fact that they will remain in a sealed cover and will only go to the SIT. So
except
therefore,
that I wonder,
there is any digression,
because you sound exactly like
thought.
the Congress did. I mean, we've repeated this point for 3 days, that this is the argument that the Congress, the UPA government made, and the BJP was all hammer and tongs at that time, breathing fire and saying, no, no, release the names. I just want to get Sanjay Hegde, who joins us again this evening, a senior advocate of the Supreme Court. The question that I asked just before you came was, where do we go from here? Mahesh Jethmalani says, look, you have a deadline now, you have dates, you have a timeline, you have a Supreme Court that says, look, we are monitoring this probe now very seriously. Would you say that that is the big takeaway today, or that there are still many question marks on how this is going to go?
Well, there are bound to be question marks, but this is a beginning. You have, even if it's a trophy prosecution as it were, that there are about 600 or 700 names. Those names have to be processed. The SIT is asked for teeth in the form of the Enforcement Directorate and the others to assist it. The processing which would otherwise have been left to the Enforcement Directorate and the tax authorities will be monitored by the SIT, which is headed by a former judge of the Supreme Court. So, in a sense, what the court has ensured is that it has its own body monitoring the work that the ED and the tax authorities were supposed to have done. So, there can be no selectivity. But of course, these accounts actually reflect a fraction of the problem. This is a beginning, but this is not the end of it.
And you say a fraction of the problem because you're saying these are not the big fish.
We do not know how much money is still left in these accounts today at the end of 2014. You must remember that this data
goes to 2006.
It goes to 2006. Yeah. In 8 years, I really suspect that there's not much left in there.
Yeah, I was going to say, if I had black money parked there once upon a time, I would have moved it out to some island by now. Yeah.
But the account statements, if you go through the accounts as to how much money came in at what point of time, if that can be correlated with other evidence, probably you could make out a case in some of those accounts.
So let me ask Aarti that, this is a very complex issue clearly, but do you think it's been trapped in this political rhetoric that we've seen over the last few years, where black money became this big election issue, where nobody really understood the nuances of what it's going to take to really get the money back, as it were?
Well,
and now people are trapped in that rhetoric.
Completely. I think the BJP is caught in a trap of its own making. But I'm surprised that the BJP did not understand this. I mean, I'm surprised they did not understand the nuances. It's not that the BJP has never been in government. After all, the BJP was in government, and the issue was raised first by a person no less than L.K. Advani, who was Home Minister in the Vajpayee government. So surely he understood, and Arun Jaitley, who is now the Finance Minister, was also a Law Minister in the Vajpayee government. I mean, they must have understood the nuances of all these things. So, I mean, I could not understand why they decided to drum it up into such a big election issue.
You think that was a mistake?
Well, I mean, the point is that, look, clearly we have a big problem of black money. And, as I think I said on your show last time, that, our politics is funded by black money. Our elections are funded by black money. So it's a problem that needs to be tackled. But whether this is the way of doing it, whether this is the, whether to make a big issue of these few hundred accounts that are lying abroad, which may be cleaned out by now because these relate to 2006. I mean, we've already had the 3 names that were revealed 2-3 days ago to the Supreme Court. I think 2 of those people have denied holding accounts.
No,
so you can already see, the kind of obstacles that you're going to run into.
Many of these people say they have legitimate accounts, or they've denied that they have accounts, in which case what do you do? So Sanjay Hegde had a point, and I'll come back to Mr. Jethmalani then. Yes.
You asked about the politics of black money and black money in foreign accounts. There was an invisible dog whistle out there, because after all, there was a question of foreign origins. So there was a foreign origins question which tied in with corruption and foreign money. It all made for a different picture, and the message which was sent out was that everything that is offshore will be brought here and that all of us will benefit. Now that rhetoric, unfortunately, is a case of advertising without an actual product being there.